Good afternoon, everyone. My name is Alexis Alvarez, and I'm the director of the statewide training initiative at Florida Legal Services. Thank you to all who have joined us today to learn about this topic. It's my pleasure to welcome you to PACE, the what, the why, the how, and the future of PACE in Florida. My job's easy today. I'm just going to give some housekeeping announcements, and then I'm going to turn it over for introductions, and then we'll turn it over for your content. But quickly going into our housekeeping announcements, first off, this is being recorded. A copy of this recording will be sent to you all who are here and registered via Zoom. Again, that'll be Zoom, not my email. So when you're looking for this recording, look out for an email from Zoom, but I am going to pop my email into the chat. That way, if you don't get it, you can always reach out to me. Housekeeping announcement number 2. This was approved for CLE credit through the Florida Bar. Yay. I will be providing you all with that CLE code at the end of our content here today, but that CLE code will also come to you in the form of email along with that recording. So don't worry if you have to hop off, if you have to get busy with other things, just look into your inbox. You'll see the recording along with that CLE code. I will announce the code out loud at the end, pop it in the chat, and you'll get it via email. Third piece of housekeeping announcements, closed captions. I have those up and running for you all, so if anyone needs that extra accessibility, you should be able to click show more somewhere on your Zoom settings. That will give you the live transcription of what we're discussing here today. If you're having any issues getting those up and running, please feel free to either email me or message me separately in the chat so I can help onboard you. Of course, it's of our utmost importance to make sure you are able to access the trainings that we offer you. And the final piece of housekeeping announcements, to me the most important, is questions and answers. I say this in every training. Everyone's probably getting sick of me saying it, but I know we live in the virtual vortex, and that makes it really hard to feel connected. And we don't want to just talk at you. We want to teach you. We want to have a conversation about this, and we want to hear from you because this is a cutting edge topic, and it's something that we are collaboratively working to understand. So if you can please drop your questions into the chat or the Q&A. We will be monitoring those questions and doing our best to present those questions to our speakers as we progress through the content. So if it comes to your mind, pop it in, and we'll do everything we can to get your questions answered. And so I know I moved through that fast. I just want to make sure we can get to the great content we have here today. I'm going to turn it over to Laura Beckman, who is going to introduce our speakers, talk a little bit about our co-host, the Public Interest Law section of the Florida Bar, and then we will dive right in. So Laura.
Thanks, Alexis. I'm Laura Beckman. I'm the chair of the Public Interest Law Section's Consumer and Tenant Work Group. And if you are not a member of PILS, the Public Interest Law Section, we strongly encourage you to join. It's a wonderful section. Dues are only $35, and it gets you access to amazing content like we're having today. And if you're in this webinar, I suspect you're probably also particularly interested in consumer and tenant issues. So we would love to have you as part of our work group as well. Our presentation today, we have 2 speakers who will be presenting to us, Stacey Tutt and Alice Vickers. Stacey is the Homeowner Assistance Fund Coordinator and a senior staff attorney at the National Housing Law Project. Her work focuses on the national implementation of the Homeowners Assistance Fund, predatory lending, mortgage servicing, and energy efficiency housing finance. She also designed and directed the Consumer Law Clinic at the University of California, Irvine School of Law. The Consumer Law Clinic focused on keeping low-income consumers in their home after experiencing home improvement fraud and advocating on behalf of vulnerable populations with government-imposed debt. She also developed and directed the Community Preservation Clinic at the University of Illinois College of Law, which provided foreclosure defense to vulnerable homeowners, developed foreclosure mediation programs throughout the state, and designed neighborhood revitalization efforts following the foreclosure crisis. And perhaps the highest praise of all is that Lynn Drysdale tells me that there is no human on this earth who knows more about PACE than Stacey Tutt. So we're very honored to have her with us. Our second presenter is Alice Vickers. Alice is a founding member of the Florida Alliance for Consumer Protection and Access Director for FLACP. Her career has been devoted to representing the low-income and housing and consumer issues through litigation and legislative advocacy. Prior to joining FLACP, she was a legal services attorney for 28 years. In 20 of those years, she was with Florida Legal Services, where she advocated for clients on tenants' rights and consumer protection before the Florida legislature. Alice has frequently testified before the Florida legislature supporting tenants' rights and consumer protection and is regularly interviewed by the media on these issues. Alice is also the recipient of the Consumer Protection Law Committee of the Florida Bar's Consumer Protection Lawyer of the Year. And she was also recognized for outstanding and tireless efforts to protect and strengthen the rights of Florida consumers through legislative advocacy. The National Association of Consumer Advocates awarded Alice the Consumer Advocate of the Year for 2014. And Alice is the most knowledgeable human I know on legislative issues. So we are greatly indebted to her for always keeping us informed of what's happening in the Florida legislature on our consumer and tenant issues. And with that, I will turn it over to Stacey and Alice, and thank you so much for being here with us today.
Well, thank you for that wonderful and amazing introduction. I really hope I can live up to Lynn's praise. That's really high compliment coming from Lynn in particular. So really, as was included in the introduction, I have been working in and around the Property Assessed Clean Energy program for really the last, I believe it's 6 to 7 years. It's been a big focus of mine. Most of my experience, though, has come from working within or dealing with the PACE program in California. But hopefully today we can share with you some of the lessons we've learned from our experiences, as well as having Alice join in to tell you more about what's happening in particular in Florida. And then in the end, hopefully we can brainstorm and even discuss more of next steps. And I believe there'll be future opportunities and webinars to do that as well. So first, in just getting started in this, I wanted to first explain what is the Property Assessed Clean Energy program. I can tell you that when I went out to the University of California, Irvine to start my clinic, I was allowed to create whatever program I wanted to focus on in consumer law. So I did a survey of our area, talking to advocates across the state to figure out what new and emerging issues they were seeing. And again, they brought up the Property Assessed Clean Energy Program, or PACE. And when I first heard about it, I was like, how in the world is that even possible or legal in this situation? And so let me tell you about it and why I was a little bit shocked to first learn about this program. So what PACE is it is a financing product that is actually brought about through working with both public and private partners. Usually for a PACE program to operate, there'll need to be a governmental entity that authorizes the program. Usually there is a statewide enabling statute, but then a local municipality or governmental entity will decide to authorize it within their jurisdiction and where they would like it to be allowed. Then you have the private lender, the financing company, that then partners and usually signs a contract with the PACE authority, that local government entity, to provide the administration of the program. And then that program administrator or lender relies upon home improvement contractors to go door to door and solicit homeowners to sign on to this financing product. The reason PACE was created in the first place was to deal with the struggles homeowners had in making energy efficient improvements to their homes. Many homeowners could not face the upfront lump sum cost of installing solar panels or making other upgrades to their properties. And so the PACE program was created in order to help homeowners afford these costs. And the idea behind it and the hope behind it was that the improvements would pay for themselves over time. And so this would allow homeowners with equity in their home to tap into that equity and make these energy efficient improvements. Again, it largely came about because homeowners struggled in getting home equity loans of credit or other things to make these improvements and really couldn't afford the cost of doing so. So PACE came about because what PACE did was allow homeowners to tap into the equity in their home. When PACE first launched, there was no requirements of ability to repay that were part of it. And so really in determining eligibility, the lenders just had to look at the equity that was in the home. And that was really the only kind of eligibility criteria that was happening. There was some look back to making sure there weren't property tax defaults or things of that nature. But to be honest, to be approved approved for these programs, it could happen within 15 minutes of providing just some basic financial information to the lending companies. So as I mentioned, this product was largely sold door to door by home improvement contractors. They would target neighborhoods where they knew there were equity in the homes and would encourage those homeowners then to sign up for a government program that would help them in installing those improvements. Oftentimes we heard from our homeowners, the solicitors would call it a free government program, often misleading homeowners as to what the product was that they were signing on. And because most of these transactions happen through electronic applications, electronic DocuSign of contracts, many homeowners didn't even realize at the time what they were signing up for, what the interest rates were, or even how they would pay it back. And just so you know, with these PACE assessments, there is interest that's charged. There are fees for origination, as well as annual fees associated with it that the homeowners have to pay, which actually make the PACE assessments more expensive than a home equity line of credit or other lending that may be out there for these homeowners. And what would happen is that the homeowners would be solicited at their front door, encouraged to make these improvements. They would be shown the contracts on a tablet or phone that was the lender, or that was the home improvement contractors, or with some of our older adults, they would even set up email accounts for them and create accounts for them to enter into these electronic transactions. Once a homeowner agreed and applied and then was approved, what would happen next is the work would commence. And then in order for the contractor to be paid for those improvements, the homeowner would just simply have to acknowledge that the work was complete. And then the lender, the program administrator, would pay that homeowner, home improvement contractor directly for all the work that was performed. What happened next was then that PACE authority, that local government entity that authorized the program, would then have a lien on the home that would be recorded as a notice of assessment against the property. Then what the PACE authority could do was have that lending product put onto the homeowner's property taxes. So what that means is that the loan would then be collected through the homeowner's property taxes, which many of you know is only paid twice a year. It's quite expensive. Or what would end up happening is if they had a mortgage, their mortgage servicer would pay the property taxes, and then it would increase their escrow payments and increase their monthly payments on their mortgages. What we found in California is oftentimes the transaction or that first payment that was due on the PACE assessment wouldn't show up on the property taxes for up to 18 months after the improvements had been installed. This led a lot of homeowners to be shocked to learn that they were paying for this product through their property taxes. And oftentimes that first tax bill was the first time our homeowners even realized that they had a PACE assessment. So why was PACE allowed to be done in this way and gone about in this? It was marketed as a product in which that homeowners could get much needed financing that they otherwise couldn't tap into, that by having it as a notice of assessment and as a property tax, the idea was then that would run with the land. That means that if the homeowner who had the PACE assessment sold the home or to another buyer, that buyer then could assume the PACE payments and the PACE assessment would run with the land. However, once PACE was announced, FHFA and FHA had a different perspective on that. And in fact, they have a position that they will not insure properties that have a PACE assessment on it. So the realities of PACE is that many homeowners then have to pay off the entirety of the PACE assessment if they decide to sell the property to someone else. Now, what we can see here down in the bottom corner of this presentation is just an example of what that notice of assessment could look like that was then recorded against the property. The other thing that happens with PACE is that PACE can lead to foreclosure. Now, most oftentimes in our experience, PACE causes a foreclosure because a homeowner's regular mortgage payments go up due to the increased escrow amount that's needed. But if a homeowner is unable to pay their property taxes, then they could face a property tax default. And in fact, the default on the PACE assessment could be stripped off of that, and then the lender could foreclose on the default amount of the property tax assessment. So this is, as you can tell, a very complicated program in which homeowners are asked to make quick financial decisions in a matter of minutes, oftentimes not understanding that they have to pay this assessment back through their property taxes, or exactly the implications of signing it, and some of the problems then of having to pay off these PACE assessments if they decide to sell their homes. And just kind of in talking about this and PACE and what we're seeing here, one important thing to keep in mind about this is that PACE assessments, on average in California, I believe our PACE assessments on average right now are around $30,000, but we have seen PACE assessments upwards of hundreds of thousands of dollars. So you can imagine that sticker shock when homeowners get their property tax bill and realize how much they are paying for this product, and realize the impact on their budgets. And regrettably, through our own work, we do not see that these products pay for themselves and often result in homeowners getting behind on their mortgages or unable to maintain their properties. So one important thing I think as we talk about PACE and try to wrap our minds around it is how are these transactions structured? Who are the players and what are their roles? So what I'm sharing here with you is just an example. This is an example from the PACE financing company program administrator called Renovate America. This company has actually gone out of business, but I think this graph here from their bond reports really shows the structure of this and the roles of the different entities within the PACE financing product. So what you have here in this orange box at the top is you have your property owner. They then sign an agreement to have a PACE assessment put upon their home. Now, typically for that, the person who is signing that notice of assessment and filing the lien against the property is your governmental entity. Here in California, one of our governmental entities was the Western Riverside Council of Governments. And so they were the bond issuers. They were the ones then who signed the liens. And you can see here then have the obligations to the bond and note holders as part of this transaction. Over here, you can see the other players that are part of this financing structure. What you have here, again, is Renovate America. That was a financing company. They were the program administrator. So for those of you who do mortgage servicing work, this is really like your mortgage originator, right? They're the ones who set the eligibility criteria, review it, review the applications that homeowners submit, and then do all of the origination work for the PACE assessments. Another entity that's involved in these transactions is called David Tossig and Associates. Now they've simplified their name to DTA. And DTA is what I would call the equivalent of a mortgage servicer. Once those assessments are in place, they're the ones collecting the payments. Well, not collecting the payments. They're ones verifying the amounts needed and due on the assessments, and then actually getting the collection of the payments through the tax assessor or the county taxing authority, which is why you see here on this chart, we also have the County of Riverside, California, because most oftentimes what needs to happen is annually the governmental entity will pass a resolution letting the taxing authority know how much is supposed to be collected from which tax rolls and then paid back on their PACE assessments. And again, all of that transacting and work is through DTA, and they do that work. So again, this is a complex transaction. And I bring this up because it is one of the greatest challenges that we have in PACE, especially in trying to address either legislatively or through litigation, these transactions. For litigation, it is complex on who you sue, who has that responsibility. We deal with a lot of claims of governmental immunity because of the governmental partners of these. And then also dealing with just liability for agents, in particular, because so many of these products are sold through through home improvement contractors, it really does make the litigation complex and difficult to unwind the transactions. So why do we have PACE? What's going on? I do want to point out this is an opportunity to blame California for this. It did come from Berkeley, California. It is our fault. So usually I know Californians blame Floridians. Well, now it's our turn. You can blame us for this product. It came out as a reaction to climate change and this desire to do energy efficient improvements. So again, here you can see this is just the enabling statute that we had in California. And a little bit of just their reasoning behind having this program and why they felt it was necessary to implement PACE. But next up, what we're going to do is, now that you've seen kind of how we introduced it in California, I'm going to turn the mic over to Alice so she can talk to you a little bit about what's happening in Florida, where the Florida legislation is, and then we're going to turn back to reflect on what California has been doing in and around this to push back on but legislatively and through other means on the PACE program. So Alice, I'll turn it over to you.
Okay. Thank you, Stacey. And thank you so much for that really clear and excellent explanation of PACE loans. Obviously, that is the basic structure that we also have here in Florida. So I'm going to start really with just how it originated in Florida and how we got into this whole mess. So I don't think this happened in California, but at the time that Berkeley originated the PACE concept, there was the Florida Tax and Budget Reform Commission meeting that year, and they rapidly created a constitutional amendment that we voted on as Floridians, and it, as you can see, it readily passed. And the purpose of the amendment was to allow for both wind mitigation, since we have hurricanes, so they're adding to the features of PACE, as well as renewable energy source devices. Those would not, if you added those to your home, whether through PACE or otherwise, because PACE did not yet exist, you would not have an increase in the assessed value of your home. So the purpose, obviously, to encourage homeowners to do these things. So next panel. And that's just the, you know, where you find it embedded in the Constitution. So you can see the source. And this is important because as we moved forward, you can go ahead and go to the next panel. To the legislation. So in 2010, we got the implementing legislation was passed. And what's important is just those two features from the change to the tax provisions in the Constitution were included in PACE. So a very short statute, it's at 163.08, provides Florida's PACE program. And it's limited, again, to wind mitigation and to the energy conservation strategies. What is fascinating, if you are following Florida politics, even remotely, I love this implementing language that the legislature finds that all energy consuming improved property, I can't see it all, improved properties that are not using energy conservation strategies contribute to the burden affecting all improved property resulting from fossil fuel energy production. You would never hear that from the legislature. Now it's still in the statute. Pretty fascinating if you follow the politics in Florida. So next panel. All right, so I think it's just kind of fascinating that, again, this is showing you just that since that implementing legislation in 2010, There have been no changes to the statute of any appreciable amount. That 2012 change may be important to get into later, but since 2012, over 20 bills have been filed attempting to amend 163.08. All but 2 of those bills have been filed by Y-Green and other industry players to make it easier for them to sell their products in Florida. All of them have died. So we're still at where we were back in 2010, essentially. Next panel. Or I think that's it for me.
So meanwhile, so now that you have an understanding of kind of what happened in Florida and the timeframes of that, I wanted to share with you a comparison of what we've been doing here in California in and around the program and kind of our response to the PACE program. So as I mentioned before, PACE came out of an initiative in Berkeley, California. In fact, they started doing PACE financing in early 2009 through their program. And that was shortly after it was authorized, and I went ahead and added in the statutes authorizing our PACE program here in California. Once it was first authorized, the next thing that happened was an expansion of the program. That included adding water efficiency, EV charging infrastructure, and other improvements to be allowed to be financed through the PACE program. In addition to that, there was also amendments to allow for other ways and improvements through the special tax, and that was the Melrose Community Facilities Act. In my experience, this is typically the method used by Y-Green for securitization of the assessments, whereas Renovate America and the others do not necessarily follow that model. So again, in the beginning, what we saw was just the emergence of PACE and that it was expanding, that what we saw happening there was increasing the amount that PACE loans could be made up to. As I mentioned before, when PACE originated, it was an equity-based financing model. And so what we saw in the beginning was allowing more and more of that equity to be tapped into and allowing homeowners to borrow more and more from the PACE program. So ultimately, what we saw over those years was a significant increase in PACE assessments. You can see in the first few years, you had less than 25,000 enrolled, and then it really started to go up to the point that it was 3 times that amount in 2016. And as I mentioned before too with PACE, it takes up to 18 months sometimes for homeowners to even realize they have a PACE assessment. So regrettably, as advocates, we were very slow to respond to this. We didn't realize this was happening. We weren't at the table as stakeholders with the initial enabling statutes and things of that nature. But as this program continued to roll out, homeowners began to realize what they had done and were struggling with making those payments. We then had to formulate a response. And when I say the advocates that responded, I do just want to introduce you to the group of advocates in California that have been working on this over the last, 5 to 6 years, because they've been such an integral part of it. And I'm going to be sharing a lot of their successes with all of you, so I definitely want to give them credit. In fact, our organization, our groups here that are represented in this coalition, you can see all their different images are made up of state legal service programs, national advocates, our California Low-Income Consumers Coalition, as well as grassroots organizations that work directly with homeowners who are experiencing these difficulties. Ultimately, we have created our own website where we house information about the PACE program and try to reach homeowners who are struggling with it. That website is just cleanenergyjustice.org. If you want to check it out, you're welcome to go look at that and some of our efforts. But now that I've introduced the advocates that have been working on this and their roles, I do want to talk about what we ended up doing. So once PACE was happening and we saw all the problems in and around PACE, our different advocates began working in order to put some additional protections in for homeowners. That includes in 2016, making sure that there was a 3-day right to cancel. One of the biggest accomplishments as well was actually getting oversight of those program administrators. In California, that was originally with the Department of Business Oversight. They were actually granted authority to license and provide oversight of this program. That organization has subsequently changed. It is now called the Department of Financial Protection and Innovation, but they are in charge of supervising the program administrators, licensing them. They also now have a complaint procedure as well as information on who are the solicitors and solicitor agents under the program. When I use that terminology, again, I'm referring to the home improvement contractors who are really the sales force for the PACE program. So that was an effort that was undertaken, was to get that. And then ultimately what happened is that the DFPI actually has issued regulations. They did a series of stakeholder meetings where we met with them to offer our perspective on what those regulations needed to be. We spent many hours in rooms with the PACE program administrators discussing the issues and problems and challenges in and around this program. If you have trouble sleeping at night and you want to read all about those discussions, most of the meeting minutes and information that came out of the stakeholder meetings are all available on the DFPI website for you. Other protections that we added in were the oral confirmation of key terms and conditions. So it is required after a homeowner has electronically signed their application, that they actually have to have a call with the program administrator, where the program administrator is supposed to explain all of the terms of the financing and ensure that the homeowner has a clear understanding of that process. Those calls are recorded. They can be very rich in litigation for looking at and assessing if homeowners really understood the terms and conditions that they were signing. And so that was another step that we took in order to combat this product. In 2018, this was a huge effort and a big win for our consumer advocates. And that was requiring that it be determined that a homeowner actually had the ability to repay a PACE loan before it could be financed. And the statute on this was very vague, but then our DFPI stepped in order to promulgate regulations on what that ability to pay assessment should be. It did take years for that to happen. However, it has been very valuable in our work as we go forward. Also, what happened is that the DFPI was required to have a public listing of all the solicitor and solicitor agents that were out there soliciting homeowners to enroll in the PACE program. This was very helpful for us in tracking who those were. Most oftentimes what we saw in PACE were significant misrepresentations at the time of solicitation. Many home improvement contractors are incentivized to get homeowners to sign up for this product because it's the only way the homeowners are able to afford the work. And so that's home improvement contractors want to ensure that the financing happens for our homeowners so they themselves can launch and engage in the product. What we started to see at this point in time is that we started to see a decline in the originations in and around PACE, and this was the first time it happened. We did hear from the program administrators that after the ability to pay was passed, that their originations dropped by about 50%. And so they blamed us for that market decline. What we saw was just a market correction, that those were unaffordable in the first place and never should have been made in the program. But that is their response to it and why they push back on those ability to pay requirements. It is more labor intensive for them to go through and do that assessment. And it really does slow down the transactions, which is one of their biggest selling points to home improvement contractors for utilizing this product and soliciting on their behalf. So then also during this time is where we focused a great deal on the litigation and really trying to combat these programs through a wide variety of cases. Now, there's a lot of individual litigation that was going on, but what this slide highlights are some of the important class actions that were happening in this area. I put in there Smith v. Wygreen because in that one, there was one of the first federal cases. This was a class that was originally was certified and then decertified by the court. And it's been an important decision in particular as looking at the characterization of what is PACE and its applicability of the different disclosures or consumer protections that needed to be in place. In addition to that, public counsel brought with pro bono counsel 2 different class actions, the Nemor and Okana class actions. And this lawsuit was largely in and around the lack of ability to pay or affordability of the PACE assessments. They brought this under our financial elder abuse, the breach of contract, and just the unlawfulness of the contracts due to the inability to pay. That was brought in 2018. I would let you know this class action has settled. The settlement, I think, is not, the terms haven't, I think, been fully announced. I think we're just waiting on, crossing the T's, dotting the I's on that. But I believe that information will soon be forthcoming on what happened with the settlement in that case. The next one I would bring up is another class action that happened in San Diego. This was in Ray Renovate America finance cases. This was brought about against the program administrators, some of the trusts and other entities that are involved in these PACE transactions. And what I think is really important about this case is it was actually in this case that we uncovered and realized that over 6,500 of the homeowners who had allegedly signed on to a Renovate America PACE assessment did so utilizing an email address that was none@herofinancing.com. So we realized this as they were trying to provide notice to all the class members, and it was uncovered by the settlement administrator that that was the email address in over 6,500 transactions. So that one was really important to us and really just showing how rampant some of the abuses are, in particular in and around the electronic signing and execution of these agreements. Now, moving on, it started getting busier and busier at that point in time. So what we started to see was that we did keep continuing to try to pass new legislation in order to add in additional protections. One of the great protections that we got was the prohibition of PACE on properties with a reverse mortgage. This is a particularly vulnerable population who, by having a PACE assessment on their fixed income, could no longer afford their property taxes or property charges and have seen a growing amount of foreclosures associated with PACE assessments. So that was a legislation we did, but we also were litigating like crazy. And ultimately what ended up happening is Renovate America filed for bankruptcy. They cited the 56 lawsuits against them as the reason for them falling into bankruptcy and experiencing those problems. And so that happened in 2020. Just so you know, Renovate America was our largest originator of PACE assessments in California. They originated about 54% of our PACE assessments. When we did a review of all the claims that were filed, we realized that in order to address those harms, we would need, I think we were looking at like $75 million and able to help those homeowners. Regrettably, because Renovate America went bankrupt, there was no money to give back to these homeowners. So many of our homeowners only got pennies on the dollar for any of their claims that they filed due to Renovate's bankruptcy. But that also then started to topple some of the other programs and players. We actually were able then to convince the county, the County of LA to end their PACE program. The County of LA was one of our PACE authorities that authorized these. They decided to end their program. And then the Western Riverside Council of Governments, that's the joint powers of authority here in California, they also voted to end their program. And to let you know, we went to every city council meeting we could, any meeting of these WRCOG, to keep asking for them to change or end their programs. Our homeowners would come, they would work to advocate for these changes and really raise it up to make it an important issue for these governmental entities to pay attention to and be aware of the harms that it was causing. Then what we did was in 2021, we were able to that's when the regulations came out from the DFPI on our ability to repay, and we started to see that happening. The DFPI also worked to revoke Renovate America's administrator's license due to the abuses that we're seeing. The DFPI has also revoked a number of solicitor or solicited agents license or ability to solicit PACE for their abuses. And so we found the DFPI stepping up and addressing some of the harms. We also worked closely with Berkeley Law's Environmental Law Clinic, who did this amazing report on the problems we saw in and around PACE, the harms that it was causing, which is really helpful in supporting our ongoing legislation and in attempts to continue to revise the program. And one of my favorite things, which I can tell you, John Oliver does it way better than I do. If you want to know about PACE, its harms in a fun, entertaining way, there is an episode on PACE. You can just find it on YouTube if you want it. I think it's the most entertaining way to learn about PACE and the problems that we saw. In 2022, what we saw is we did many thanks to the FTC v. Wygreen case that was brought against Wygreen. It resulted in a settlement of $3 million in lien relief, as well as a permanent injunction about unfair deceptive practices that were going on. Because of that, or following that, Wygreen did announce that it would no longer be originating PACE assessments in California. And so they have largely pulled out of our market here. You know, we also extended our efforts to help others who are working on this. And then a big part of our attention was focused on helping and working to inform the CFPB's rulemaking in and around PACE. Because you can see here, they were tasked with rulemaking in and around the PACE program, and in particular, establishing the ability to repay rules and regulations for the PACE program. I'm happy to say that after years of effort and commenting and participation, the proposed rules were published on May 1st of 2023. You can find those on their website, as well as you can go and look at the comments that were submitted as to those regulations and the things that we thought were most important or need of clarification for the final rule. But really what was significantly helpful that the CFPB did, and why it took so long, is they were extensively researching PACE, trying to determine its impact. I can tell you from all the work we did legislatively and our efforts, data was the one thing that was challenging for us to get, to be able to evidence how it really negatively impacted homeowners' financial circumstances. And so the report that the CFPB has put out really highlights the impact of these, in particular in California and Florida. So this work has been exceptionally valuable, not only to support the rulemaking, but also to kind of support our efforts. So now wanted to talk, and now that you know what happened in California, our experiences of it and things of that nature, you know, we wanted to talk a little bit about the future of PACE in Florida. So I'm going to turn the mic back over to Alice to talk about what is happening there.
Thank you, Stacey. Y'all are probably going, what's the matter with Florida? Why is none of this happening in Florida? So let me back up for just a quick second. The structure, as I said before, at 163.08 is basically the same as California was originally before all those great amendments Stacey just told us about. So I'm not going to go over that. But a huge difference in Florida is there is zero state agency oversight of this program. So for that reason, we have not had any data available unless you manually draw data county by county going through the property tax records. So this has been a wild west here in Florida, with each county either individually or through interlocal agreements going forward with trying to create their own PACE programs and being constantly lobbied by the entities such as Wygreen, et cetera. And in terms of so I'm not going to digress from that. So let me continue. So when PACE was passed in 2010, the implementing legislation, there were several entities who did get bond money. So the bond money is how the financiers have gotten the funding for this. Can you go back to that other panel so I can look at that while I'm talking? The panel before. So there was litigation in Florida around the bond authorizations and the bond validation proceedings that went through the Supreme Court. There was some test of the entire statute itself. There was a flurry of litigation between 2010 and 2015. All of it came out favorable for the industry. So by 2016, we started to see PACE. The Supreme Court had supported everything, the statute and the bond validation. This article that I've listed here in the Florida Bar Journal from 2016 is the best synopsis of all the litigation. If you want to go back, look at that. It gives you a good overview of the history. So moving forward to the next panel now. So in Florida at this point, things have just gone off the rails. So back in October of 2022, there was a bond validation hearing in Tallahassee in Leon County before Judge Lee Marsh by Florida PACE Funding Agency. So Florida PACE Funding Agency is a quasi-governmental entity that was created by interlocal agreement between the city of Kissimmee and another county, which escapes me right now. And the Florida PACE Funding Agency did not do any Flagler. Yes, thank you, Flagler County. The Florida PACE Funding Agency merely provided the financing. They did not do the program administrating. So they would pair with entities like Renovate and Renew and Y Green, Fortify, those types of places. But at any rate, in 2020, they got this, 2022, they got this bond validation. And in this 50-page order, they got Judge Marsh to interpret 163.08 to say that Florida PACE Funding Agency did not need to operate through any of the counties, but could operate freely throughout the state of Florida. So since they got the decision, that is what Florida PACE Funding Agency has been doing, much to the consternation of over 30 counties in Florida who do not want them operating in their counties. And you can, I'm not going to go into all the litigation there. But at this point, as Lynn, I think plans or the PIL's plans for the future, there is some really good litigation out of Leon County by the Leon County attorney that is pending, that is testing or that Judge Marsh overreached beyond what he could do in a bond validation proceeding, that he could not interpret 163.08 in the course of a bond validation proceeding. So tandem with the litigation that is going in the state, we have two bills at the Florida legislature that are fighting each other between the two houses that are attempting to address the issue of Florida PACE Funding Agency. So we're hoping that either through the courts or through the legislature, we will see Florida PACE Funding Agency being reined to operate through local governments or interlocal agreements and cannot freely operate throughout the state. So that's where we are in Florida right now. Very dicey times for the PACE program.
Thank you, Alice. That's why we're here, right? We are concerned about all that's going on. Now, Elizabeth, I see that you have your hand raised. I believe we can unmute you if you'd like to go ahead and ask your question.
Yep, and let me get to Elizabeth here. 1 second. Elizabeth, I am giving you the ability to come off mute. Talking is permitted, so you may feel free to pose your question.
Oh, did I lower my hand already?
No, it's up.
Okay. I wanted to know, because you're talking about PACE and I work in fair housing, for the FLS unit. And I wanted to know if there was a connection that I could possibly do when I'm trying to set up lending tests, and even possible appraisal tests later, if we're able to do that. And I kind of wanted to know if you had any type of advice you might give me for trying to set that up so that way we could possibly, get concrete evidence for this type of lending, or how to help people work through it and manage it later if someone ever asks anyone in our unit.
Elizabeth, that's such a great question, and definitely something that we've been trying to work through here in California as well. We do believe that there is a targeting of particular neighborhoods for this product. And we've also seen a lot of concerns in and around, in particular, with homeowners in which English is a second language. We've seen lots of problems in and around this in California, in particular because of our requirements under the Home Solicitation Act. In which anytime a door-to-door sale is negotiated in another language, that then the contract is supposed to be provided in that other language, and to allow that access and information on that. And so we have seen that targeting that's been going on, but as Alice mentioned, the data has been really challenging for us to gather that information and be able to show this impact that we're seeing within particular neighborhoods. And so, I would just say that we know that problem is there, but I think it could be a great discussion for in the future of how we can try to demonstrate that trend that we see within this product. So
I'll just add,
go ahead, Alice.
I'll just add real fast. I don't have the article in front of me, but it is possible to get that data. Again, it's very work intensive. There was an excellent article several years ago out of Central Florida area. The reporter went by zip code and went into the lower income working class neighborhoods where English was not their first primary language. And she was able to see she was able to go to the tax collector's rolls, and she was able to see how they were going door to door and selling the product within that neighborhood. It's a great expose of one industry, one player, and I can't remember which one it was, going into that neighborhood and preying on these homeowners. And unfortunately, in Florida, unlike it sounds like California, there is no protection for those for whom English is not their primary or first language. Nothing in the statute requires them to provide these homeowners with anything in their primary language. So at least anecdotally, we know many of these people have taken out these loans and never even understood the nuts and bolts of what was happening to them. But it can be done if you're working within a single county. It's just very work intensive right now to collect that data.
Yeah, and the problem we actually ran into in California is we do have what's called a loss reserve fund, which is to protect mortgage lenders if there's a PACE default. And so with that, there is a registration that's required where they actually are supposed to provide the APNs for every property that had a PACE assessment on it. The challenge we ran into with our data, which hopefully you won't have in Florida, is that the APN numbers could actually be the same APN numbers from different counties. And because the data wasn't collected county by county, and many of our county tax assessors would not respond to public requests for information with that because it is searchable within their offices. We really just hit a wall that it became way too labor intensive to do all of the mapping in and around this. We do have some mapping of that with GIS. In particular, we were looking at the impacts on low income older adults and showing the targeting of that, given the significant equity in their homes. We have a few of those maps, but as Alice said, it's very labor intensive, and that's been one of our greatest challenges in documenting it, which was a lot of the value that we got out of the CFPB report, especially because they actually were using credit report data as well to show those negative impacts of the PACE assessments. And so as you can see here on my slide, I actually do have together for any of the litigators in the audience, just a bit on the litigation we have done in California, including our common causes of action that we've brought in response to these, as well as the typical demurs or motions to strike that we get from the program administrators, the defenses that they bring up, our challenges with the Government Claims Act, administrative exhaustion, and arbitration clauses. So just know we have that as a future reference if anyone is interested in those materials or for future presentations.
Awesome. Thank you so much, Stacey and Alice. What an expansive conversation, and what a just incredible conversation to have and bring to really meld Florida and understand what's going on in California and see where we can be and where we're going to be and what we can do. So thank you so much for providing this educational opportunity to our advocates. I am going to fill up some airtime while we encourage folks to continue to ask questions in the chat or the Q&A. Additionally, if you, similarly to Elizabeth, prefer to pose your question off of mute, please raise your hand and I'll go through the exact same process and give you the permission to talk and pose your question that way. Briefly, I do want to put the CLE code into the chat. That CLE code is 8310. Again, that's 8310, and that is for one general CLE credit approved here in Florida. So I see some stuff coming in through the chat. I don't see any questions, but I don't know if either, Stacey or Alice, if there's something that you want to comment on of what's coming into the chat. I believe there's some articles that are being referenced. Might just be more resources.
Well, and I would just add in on the discussion of trying to document the disparate impact and things like that. We also did a story gathering series with our homeowners, trying to gather their stories and experiences with the program. We did highlight some of those stories on the Clean Energy Justice website. So if you'd like to see that, I'm going to put that link in the chat as well, just so everybody has it in case you want to see some of the efforts in and around that from the California Coalition.
Thank you. That's very helpful. And I'll make sure that that link and any other resources that are mentioned here are included in the email along with the recording and the CLE code. So with that, I do want to say that this was part one. We have a part two to continue the conversation about PACE. That part two is going to be coming out in February. We're still working on a date. All of you who are here will get direct information on how to register for that part two. I will say that part one was a great way to start, and part two is going to be just as wonderful. So I do see a question really quick in the chat. Yes, I will send out. The question is, excuse me, are we going to be sending out the recording and plus the chat so they have the articles and the links? Sure, I can include a transcript of the chat as well. That way, the links are right then and there. And then there does seem to be a last minute question. Stacey, Alice, do you have time?
Yeah, and I would just say to Marianne, yes. I mean, that often happens in which the homeowners led to believe that this is a free governmental program and that they're going to benefit from this, when in fact, the reality is the public entity has little to no oversight or evaluation of eligibility in this program. We've done a lot of litigation in and around this to kind of establish those agency relationships and liability for that, as well as addressing those misrepresentations. And so I know that I put together some materials in a drive. Are those shared out? Okay, so we did include in our resources and materials some of the litigation in and around this, some of the complaints that are there. So if that can help give you an idea of ways that we've pushed back and combated with this. And I would let everybody know, I do maintain a database of almost all the complaints I found in California or anything I've been able to glean or been shared with me. So I'm also happy to share those complaints with you, kind of how they turned out and what we're seeing in and around the litigation specifically, but that's probably a pretty extensive topic that we should hopefully get to talk about at one of these later dates.
Absolutely. And so I will make sure, again, along with that email with the recording, the CLE, I'll add the chat. I'll make sure also there's a link to that drive folder that you sent me, a copy of that drive folder that has all the materials that you shared with me. Thank you so much. Lynn, I see Lynn Drysdale here with us. Is there anything that Lynn wants to add?
Not really, but I did see that there was another question about if anyone knows any litigation where the homeowner is led to believe that the county is engaging in PACE when it really does not. And then they find out that they have a lien on their property for the financing. And I just wanted to let you know that Duval County, where I practice primarily, well, they have, that's one of the counties that has, where the tax collector has said that they're not going to put these non-ad valorem assessments on the tax rolls. And so there's litigation pending relating to that. But we have been going through the public records and getting information about where these liens are. And Duval County does not allow PACE, but yet there's probably over 200, maybe even 300 notices of assessment and liens on PACE loans in Duval County. So all of this is sort of evolving. So I'm not aware of any litigation on behalf of brought by an attorney working in the private sector or legal services in Florida yet, but anticipate that that will be coming up because there's a lot of problems that the contracts are creating by this by the Florida PACE funding agency's action in telling the tax collectors and property appraisers what they were supposed to do.
And I would just add on to that, in California, we haven't had that problem where there wasn't an area that PACE had been authorized by a governmental entity in which they were being assessed. However, we did have county tax assessors who were refusing to put them on the rolls because they thought they were predatory and fraudulent and wanted to push back on it because of the negative impact on collecting taxes. However, the program administrators came out in full force with demand letters and all of the basis in which they felt they could not refuse to put them on the tax roll. And eventually our tax assessor went ahead and put them on. So there was no litigation around that here, but I'd be happy to put you in touch with those tax assessors who are trying to push back in that way and what their experiences were in navigating that with the program administrators' pushback that they experienced.
Well, that would be extremely helpful. And if I can, oh, I'm sorry, Alice, go ahead.
Well, I was just going to clarify that what you're talking about is the problem created by the bond validation decision out of Leon County, which according to Florida PACE Funding Agency is allowing them to operate freely throughout the state. And so the conundrum that we're talking about with the tax collectors is because they do not have the authority to place the liens on the property from their county, because the Florida PACE Funding Agency is freely operating statewide. So that's why we're off the rails and it's a total mess here, and why we're seeing the confusion among homeowners.
Yes. And if I could put in another small plug for the seminar or webinar next month, because we will want to make that a lot more interactive now that you've got this base. And so that will be one of the things that we'll be talking about, is how to help all of these homeowners that keep calling you, telling you they don't know who to pay because the only way to pay in the contract is through the tax collector, and the tax collector is not. So the lenders have been telling homeowners that what they should do is just contact their mortgage company and ask their mortgage company to add another $3,000 to their escrow account, which is pretty illegal for the mortgage companies to do since it's not appropriate for under the terms of the mortgage. But anyway, we'll be talking a lot more about that next month. And I just cannot thank Stacey and Alice enough for doing this today. It's been incredible, and I've learned so much myself. Thank you.
One last question. Have time? All right, something came in through the Q&A. The question is, can you expand on the 2021 California legislation, which you spoke about, protections for senior homeowners via door-to-door sales?
Yes. So what we did with that, and that was actually, interestingly enough, a joint effort with our realtors as well as mortgage brokers. They were both in support of this effort that we were doing. The legislation that we added in, that we were trying to create those protections, included for seniors a longer right to cancel that was 5 years, as well as a particular disclosure requirement that was in hard copy that had to the homeowners had to go through in acknowledging some of the unique nature of the PACE transaction and its cost. I'd be happy to share with you that legislation and what that looks like in California.
Awesome. Thank you so much, Stacey. So, through the chat, I think what I see here is mainly thank yous for an excellent program. Thank you for an informative program. Many accolades, well-deserved, Stacey and Alice. Thank you so much for all that you do in this sphere. Thank you for teaching us about it. And with that, I think that we'll sign off for the day. Thank you again. Have a good rest of your day. We look forward to part 2. Bye, folks.